Burlington, I believe.
Judge, we're trying to locate Mr. Burlington now.
All right, sir. Very good. I had asked Mr. Moon for you to also join us because we're dealing with the same case on both. So just to try to figure while we have all the attorneys present.
Judge Kuzam, we're trying to deal with the clerk's office. He says he's logged in as an attendee, but we don't have him on our screen and neither does IT. So there'll be a short delay until we can get him logged in and onto the screen.
All right. No problem, Mr. Florence. Thank you, sir. I know our court works with all of you ahead of time just to make sure, but sometimes these little glitches occur, especially in your case when you're at the 11 o'clock as opposed to the 9:30. So hopefully, because I do know that he did check in earlier as well. So hopefully we'll figure this out. Thank you, gentlemen.
Very good.
Judge Kuzam, we're trying to get him to call in on
Okay.
one of the numbers. He says he's on our screen, but he's still not showing up.
All right, sir. Thank you.
You're welcome.
Can the court hear me now?
I can, Mr. Burlington, but I think there's a little bit of an echo. In fact, let me suggest this. Mr. Moon, I may trouble you to mute your microphone and then whoever's going to be making the argument first, hopefully that will take care of some of the echo. Can you hear me, Mr. Burlington?
Yes, yes, I can.
Wonderful. That is perfect. Well, let's do this. And the beauty about technology is that we will do the best that we can under the circumstance. But gentlemen, I've asked the deputy to get you all in because we are dealing with the two cases. They are traveling together. We're dealing with the same probate itself. So how do you wish to handle that, Mr. Burlington? Do you wish to, I know you're involved, you're the same attorney involved in both cases. Mr. Moon is also participating in the last case. How do you wish to handle this in terms of time-wise?
Mr. Moon and his client have graciously allowed me to argue the entire case. So I would like to argue both. Do we have 20 minutes?
Yes, sir. And if you'd like, because there are two cases, I could even give you a little extra time.
Oh,
We could go through 25 minutes if you're handling both cases. Are you doing each one individual, or you're going to handle them all together?
I think it makes sense to handle them, together, and 25 minutes is great. And I'd like to reserve 5 minutes for my rebuttal.
Excellent, sir. So let's proceed in that fashion. So at this time, I'm going to ask Mr. Moon and Mr. Friedkin to try to mute their microphone, and then
Your Honor, can I just ask a question, please?
Yes, of course.
Do I understand that we're going to each side argue both orders under appeal, like in one 40 or 45-minute block? Or are we going to argue first the removal order and then the other order, the granting of the striking of the untimely claim?
I'm happy to do whichever way, but as I hear from Mr. Burlington, I think because he's going to be arguing both cases together, as I understand it, he's going to handle both cases, and he asked for 25 minutes to handle both the issues in all the cases. Is that going to be okay for you, Mr. Friedman?
It is, if it's okay for you.
We are happy to serve whichever way, and I think that may make more sense because we are dealing with the same estate. Yes, there's different, and then Mr. Burns will go through all the different issues, and then you'll have an opportunity to respond to all that. Is that going to work well, Mr. Burlington?
I hope so, Your Honor. I'm willing to go that way.
Very good. All right. So whenever you're ready, we're ready as well.
Okay, Your Honor. My name is Philip Burlington. I represent the appellants, Andrew and Lori Kada, and because Lori is joint appellant on the second one, I'll argue that one first to make sure that she does not get shorted on time. The second one involves whether the trial court erred in determining that the challenges raised by Lori and Andrew and other siblings to the estate's assertion of ownership of 100% of the shares of ICM is barred by the 3-month deadline for creditor claims contained in statute 733.702. It's our position that the trial court erred and that this is a question of law. The definition of a claim in 733.201 sub 4 is that it is a liability of the decedent arising in contract, tort, or otherwise. And the case law, as we have outlined it in our briefs, is very clear that the liability has to exist prior to the death of the decedent to fall within the category of creditors' claims governed by the deadline in 733.7021.
And I appreciate, if I may, Mr. Burlington, and I appreciate you're making that, but if I may, my question to you, didn't your client, Lori, and let's use the first because they both have the same last name, so forgive me for just referring to her, didn't she, in her affidavit, that she swore that the decedent at the time, and I'm reading from her affidavit, at the time of his death, the decedent owned 100% of the issued and outstanding shares of ICM. Do you dispute that she made that allegation?
No, Your Honor, but there was a clear misunderstanding at that time due to the unusual ownership history of this corporation. And when the original probate judge entered the order appointing Andrew Kada as the administrator ad litem, there was the recognition that the ownership issue was not resolved and that there were other documents that could deal with that issue, and Andrew Kada was authorized under that order appointing him, among other things, to collect any documents relating to the ownership or possible transfer of ownership of ICM. So at that time, the court recognized that there was uncertainty, and that uncertainty has clearly developed through the investigation to show that there have never been any shares of ICM titled in Hassan Keda's name, that the only shares that now exist that are potentially valid, and the court hasn't had an evidentiary hearing, but these are the ones issued in 1999 that were issued to the siblings. And since 1999, Hassan Keda has never asserted ownership to ICM in contravention of those shares. He's titled no shares in his name, either certificated or uncertificated. He has not interfered with the shares that were issued, and in fact made representations subsequent to that that he did not have any ownership interest in ICM. Now, the personal representative relies on the internal revenue tax filings of the corporation, which are frankly inconsistent. As Your Honor may recall, the original incorporation of this company, the shares were issued to a gentleman named Al Jabril, not to Hassan Keda. And there was uncertainty from the outset because there was a New York court determination that the creation of ICM was designed to evade creditors, and thus there was obviously some subterfuge involved in how ICM was created.
But if I may, Mr. Burlington, as I see here, wasn't there evidence presented that the decedent, didn't he assert beneficial ownership of ICM before his death? Isn't that in the record as well?
The only evidence that we have seen of asserting beneficial ownership, which is separate from title ownership that would trigger a creditor claim situation, is in 1999 March, he made an assertion to the auditors of ICM that he was the owner of the corporation. However, 6 months later, the Articles of Incorporation were amended to authorize the issuance of 20,000 shares, and 2 weeks later, thousands of those shares, virtually all of them, I think, given over time, were issued solely to his children. So the assertion made in 1999 is not inconsistent with the subsequent issuance of shares, and he has never done anything to undermine those shares, issue any in his own name, and the assertion by the corporation in the tax returns is not a declaration of ownership that would create liability to the siblings to trigger a creditor claim. It might create liability to the IRS, but the internal audited financial statements throughout that entire period for the corporation consistently state that the siblings are the owners of ICM. So there are... Sorry.
I understand, Mr. Burlington, your position, but we're dealing here, I guess, and did we lose you? Mr. Burlington?
I'm sorry, we're dealing with what?
Oh, good. I thought I lost you. If I may, but we're dealing here with a statute of limitations, for lack of a better word, a statute of limitations. And basically what the statute requires, that if a decedent, you need to bring in a claim within a certain period of time. And what is required is, I know right now you're going into who may be, ultimately the beneficiary and so forth, but if there's a claim that needs to be made, whether it mentions whether you're a beneficial owner or based on your client's affidavit that the decedent owned 100% of the shares, doesn't that trigger? Shouldn't they have filed a claim within the time period? And why is the court wrong in coming to the conclusion that they should have done it at that point, and the petition for direction is basically an untimely claim?
Because this is not a creditor claim. That deadline applies solely to creditor claims, which are defined in 733-2014 as a liability of the decedent, arising out of contract, tort, or otherwise. The ownership of ICM, there's nothing Hassan did prior to his death that created a liability that the siblings had to respond to and would have created a creditor claim. All of the cases relied upon by the trial court were ones where the decedent, prior to his death, had taken jointly titled assets and transferred them to an account solely in his name. They were all husbands. And that was done prior to death. Those are the cases that say it's a creditor claim because that liability for that conduct occurred prior to the death. Here, this assertion of ownership of 100% of the shares appeared in the inventory and the petition of the personal representative after the decedent's death. And we've cited cases that make that distinction, including out of this court, that if it is arising out of conduct or facts developed after the death, that is not a creditor claim, and therefore it doesn't fall under that statute. I need to move on to the removal briefly. Andrew was removed for a supposed conflict because the evidence that was being developed demonstrated that Hassan had no shares titled in his name. That is not the kind of conflict that justifies removal. It is required that whatever conflict there is, it will or may interfere with the administration of the estate. Here, nothing Andrew did interfered with the administration of the estate. The administration of the estate is governed by the development of facts and evidence to determine the rights of the estate, beneficiaries, and third parties, and that's all he did. The trial court apparently concluded that because the evidence that was developed showed that Andrew and his siblings had an ownership interest in contrast to that of Hassan, but that if it is simply a conflict in claims as to assets, if that is the standard, which it's not under the statute, then no close family relatives could hardly ever be personal representatives. It is not a conflict.
Actually, from what I understand, the judge's order, Mr. Burlington, that she was concerned with the fact that when your client asked to be immediately on an ex parte and immediately to be set as an emergency guardian ad litem, he at the time made representation that he did not have any interest at all. And this was concerning to the court because in actuality, he did have significant conflict of interest, as I understand the court's ruling.
Okay, Your Honor, that order, Andrew did make that to the best of his knowledge and belief. It was a qualified assertion. We cited the case law that that's not the same as, because it's not a fact. It's obviously a question of law as to ownership. Secondly, that same order specifically directed Andrew to do an investigation as to the ownership for the transfer of documents and other information because it was uncertain. And so the court recognized that this issue was not resolved with any type of certainty. And therefore, that assertion, which was qualified, and Andrew explained at the hearing why he believed that, and the facts that were developed through the documentation, especially the discovery of the amended articles of incorporation, demonstrated that the shares issued to the children were authorized. They were previously believed to perhaps not be under the original articles of incorporation. And there's no evidence Andrew knew that at the time that he filled out that petition and gave a qualified statement as to what he believed at that time. So it was not perjury, it was not misleading, and the court's order recognized that there was uncertainty as to ownership, and that's why Andrew was authorized to develop the evidence regarding ownership. And as to waste or maladministration, it's undisputed that he increased the profitability and value of the corporation in the 2 years in which he was administrator ad litem. He did not spend a dime of the estate's money, and his treatment of the bonuses was consistent with the history of the corporation, the advice of the corporate accountants and attorneys, and he parked all of the money that were bonuses to him and said, I'm not touching this until there is a resolution. So he's done nothing to waste or maladminister the estate, and so therefore there was no basis for the removal. But under these circumstances, it would be not only in violation of the statute as to the definition of what is a creditor claim, but it would be exceedingly unfair given the admittedly convoluted situation with the ownership of this corporation. And in respect to that, the personal representative, and this is undisputed, she had in her possession from the outset the 1984 stock book for ICM, which showed that the original shares were issued to Mr. Al Jabril, not to Hassan, and she held on to that for 18 months before turning it over to the administrator ad litem. So she was on notice because there were no shares in that 1984 stock book issued to Hassan, and the PR's attorney admitted at the evidentiary hearing at page 152 that he had never seen a single share of ICM in Hassan's name. So under these circumstances, not only the provisions of the statute, but the equitable considerations mandate that these siblings not be deprived of their ownership interest in this corporation, for which, as the evidence stands now, there is nothing supporting the personal representative's assertion of ownership of 100% of the shares of stock in ICM. And I'd like to reserve the remainder of my time.
Actually, just one quick question before doing that, Mr. Burlington. I'm looking at the order that Judge Cryer entered, and how do you respond to the allegations that your client, when you've indicated that there's really no mismanagement and maladministration, but isn't there in the record that he transferred, and I'm looking at the order amount, almost like millions of dollars from ICM to himself? How do you respond to that? And this was not done with approval. He did that solely on his own accord, did not get board approval, contrary to the bylaws of ICM, and failing to do an accounting. Help me out with this.
Okay. He did not transfer anything in violation of bylaws. The evidence is undisputed. He consulted with the corporate accountants who had provided tax strategy for the history of this corporation and corporate counsel, and it required that the bonuses be deposited in the individual's account in order for the tax benefit to accrue. And the testimony.
And if that's the case, and if he was relying on someone, shouldn't he have gotten board approval or notified the board or let them know? Because again, he is the position that he's been placed in. Even if you take the position he was well within his authority, shouldn't he have done that to at least to alert them?
Your Honor, at the time, the only board members were Andrew and Lori. The PR claimed to have an interest, and she unilaterally, without notice to shareholders or anything else, created a second board, and they never really operated. And everything that Andrew did was with notice to the PR. Engel was consulted. There's test from the independent, who was the corporate accountant, that they had conferences regarding both years on bonuses. And so it was not done either surreptitiously, and it's undisputed that he has parked that money, has not spent a cent of it, and they tried to reach an agreement on an escrow, and they couldn't agree on the terms. But it's been untouched. So he hasn't done anything to take anything away, but he had to deposit it in his individual account as the accountant for ICM, an outside accountant who's a tax advisor, said had to be done to get the tax benefit.
Thank you, sir. I know I peppered you with a lot, Mr. Burlington. You still have, actually, believe it or not, you still have a few minutes, and you'll still have your full 5 minutes rebuttal. So you have a couple more minutes if you wish to make any further argument.
Well, let me go back briefly to this creditor claim, and it's called a creditor claim for a reason. But there was no action that the siblings had to bring or could be justified in bringing prior to the death of the decedent on this ownership issue. The shares had been issued to them. There was Hassan never tried to void those shares. He never issued any in his own name. He did nothing to create a liability prior to his death, and that is the singular criteria for being a creditor claim for which the 3-month deadline applies. And we've gone through all the cases cited by the trial court, and they're all ones where action was taken prior to the death of the decedent that unequivocally asserted the decedent's ownership over what had been joint assets. And this is a different situation, and we've cited the cases that say that that deadline does not apply when an ownership dispute arises after the death of the decedent. So we believe that as a matter of law, we do not have creditor claims. We have an ownership dispute, and the investigation was necessary to develop the facts, and the initial probate judge recognized there was an issue regarding it and authorized the collection of that information, which has led to the clear and at this point undisputed fact that Hassan Keita never had any shares in this corporation.
Very good, Mr. Murthy. Your timing is perfect. You'll have your full 5 minutes for rebuttal. All right. So at this time, Mr. Friedkin, can I have you respond?
Yes, thank you, Your Honor. Let me pick up on your questioning before I go into why this removal order must be enforced and should be per curiam affirmed. You asked about Lori Keita indicating that she was 100% owner. She did indeed back in August of 2016. She filed an affidavit that described that her father had served as the chairman of the board of ICM since its inception over 20 years earlier. She testified that he did all the hiring and firing. She testified, this is all by affidavit under penalty of perjury. She testified that he was, at the time of his death, the 100% owner. Andrew Keita similarly made sworn representations to then presiding judge James Schenko that there was no dispute that the estate owned and was holding 100% of ICM. So you've got the two protagonists here, both under oath during the period of the notice to creditors when if somebody thought they had a claim of ownership to ICM shares, they were required to make it. And in that regard, it's not only that information, but it's in the record of the proceedings before Judge Creer that the in-house accountant, Mike Riley, gave testimony that Mr. Hassan Keita, the decedent, would distribute bonuses of profits in all the years and would disperse the money to himself. Those are Mr. Riley's words from the trial because he knew Hassan Keita was the boss. He was the person who during his lifetime asserted 100% ownership, whether there were somebody else out there or not. You also have Exhibit 13. This would be Andrew Keita's exhibit at the trial, which shows the history of distributions, and it shows that Hassan Keita was distributed essentially all of the profit. And I'll get to that in a moment when we go through the findings. The point being here that when they file, I'm just going to divert for a moment to the petition for instructions. When they file that 3 years after death, there's nothing in the probate code that would allow that. By that point, it's already barred by 733.702 because the notice of publication happened in August of 2016, August 1, and the non-claim statute ran on November 1, 2016. So filing a petition for instructions 3 years after the decedent's death is barred by the statute of limitations. Let me take your honors back to what Andrew Keita brought to Judge Schenko back in August of 2016, which led to his appointment. And this is in the record at page 23. Andrew tells Judge Schenko, it is believed that a last will and testament of the decedent may be found. He's telling us under penalty of perjury to Judge Schenko. No last will and testament was ever found. He tells Judge Shenko it is believed that a nuptial agreement will be found or exists. None does, none ever did. Lastly, and now I'm reading for what he told to Judge Shenko and what notice he imparted. He says, it is believed that a shareholders agreement and documentation reflecting the transfer of ownership of ICM may be located. Now, this is a very important line, this next one. Billing records evidencing the preparation of the aforementioned documents are attached here to as Exhibit A. And then Exhibit A has two bills, one from 2009, one from 2011, that specifically describes a specific shareholder agreement. What else does he tell Judge Shenko under oath, under penalty of perjury? He tells Judge Shenko that the principal asset of the estate is the common stock of ICM stock. He tells Judge Shenko under penalties of perjury, there is no dispute that this property was the decedent's property and is held in his estate. And in that same portion of his application to the court, he says, and I'm quoting, the assets in question are indisputably owned by the ward. So this is what he tells Judge Shenko. This is how he gets ensconced in an order that didn't turn him into the czar. It didn't turn him into a king, and it did not turn him into the sole shareholder who was his father. It turned him into the personal representative. It gave him the powers of the personal representative. That application and the powers of the personal representative do not include spending $1.7 million or more to undermine the estate's ownership interest in ICM. He was empowered for a very limited purpose to see if he could find the shareholder agreements that he referenced, and of course, those have never surfaced. So he was removed under the provisions of Florida Statute Section 733.504. And they provide that the probate court shall remove an administrator, or in this case, administrator with personal representative powers, for wasting or maladministration of the estate, and for holding or acquiring conflicting or adverse interests against the estate that will or may interfere with the administration of the estate as a whole. Now, this order that Judge Creer entered, removing Andrew from his position, is entitled to great deference. She's entitled to be the judge of the credibility of the witnesses. She is to be reviewed on this removal petition for an abuse of discretion. So the real question that I suggest that Your Honor should be asking yourself is, was there substantial competent evidence to support the rulings of the trial court below? And if the answer is yes, then an affirmance is required.
And
So
Mr. Burlington, let me have you address really quickly, because I know Mr. Burlington made a big point talking about the stock certificate, Correct me if I'm wrong. There's really no, and maybe this is a question, Mr. Burlington, is that you really don't need to have a stock certificate in order to assert beneficial ownership.
that is absolutely correct.
All
That
right.
is absolutely positively correct. There's no law out there that says you have to have a certificate. And the fact that he is exercising day in and day out during his lifetime beneficial ownership and having the totality of the profits, his bonuses year in and year out, going way back in history, and you can find all this in Exhibit 13 at trial, he was getting all of the profit of the company. And why? Because he was the 100% owner. And no one, he didn't ask himself to show a share, and he wasn't required to show anyone else, unless there was somebody like Andrew Cada who thought, well, Dad gave me some shares. And of course he testified below that he knew that there were some shares in his name. He didn't assert it because a lawyer told him that they weren't authorized, and he chose at the same, before he made his sworn statements to Judge Schenko, he actually was on notice that there were, quote, shares, close quote, in his name and in the names of some of his siblings, but they were never delivered and they didn't act on them.
And I think, Mr. Freakin, as I read here, Judge Cryer was alarmed. Maybe is a good. You could see based on her order, she was really alarmed and concerned by virtue of the fact that at least there was failure to disclose that. Because there's a failure to disclose that he somehow, it does create a conflict of interest, whether you may or you may not, or if you think it's not valid shares, that's beside the point. Is that making sure that you do have someone appointed that will be free from any type of conflict for the benefit, because you're dealing for the benefit of the whole estate.
Well, and so the greatest example, and there's plenty of examples if we go through the removal order where each finding is supported by substantial competent evidence. But the biggest one is these giant distributions that Andrew Cada made to himself. He wasn't the czar. He was appointed with the powers of the personal representative. And under the law that they cite in their own reply, it says that a PR doesn't get to come in and run things. They don't start to use the assets of a corporation as their own personal piggy bank. He was required to follow the bylaws, just as the personal representative, my client, sought to do before the ex parte order.
Do you think, Mr. Freakin, that your analysis changes by virtue of what Mr. Burlington said, that yes, he did take all that money, but he kind of, quote unquote, parked it with himself?
Quite the opposite. Quite the opposite. It's a catastrophe for the company. The new board is struggling with what Andrew did, and this was in many respects an admission he knew he was doing wrong, is he distributed it as a bonus paid to him at his very high tax rate. So he had big deductions out of this. He parked it because he knew that what he had done is he had distributed the profit, which in historic terms had gone to his father, who was the sole shareholder. Now, we know Andrew wasn't the sole shareholder. He asserted an ownership interest in 2018, but then on the eve of trial, he dismissed his claim of ownership and in that respect gave up his interest. But when it came to his secret distribution of profits, he paid his own internal tax rate. Plus, he has tax returns now for ICM, which show him getting that money. One of the things ICM is struggling to do is how best to recapture that money. And this is all going to happen in a surcharge action. Recapture it and restate the tax returns and not open up the gigantic can of worms with the IRS that Andrew's sole action taken without any authority has caused. So that's one huge piece of waste and one huge piece of maladministration that has actual effect on the administration of both the estate and this corporation. But it doesn't stop there. He misunderstands his own fiduciary duty when he tries to read Judge Schenko's order as authorizing him to undermine the ownership in the estate of this asset. Nothing in Judge Schenko's order gets anywhere near that. But what does he do? Once he starts on the scent, and he never comes and tells the court this, we don't really learn this until he files his claim, but he spends just under, we think by the time it's done, something in the neighborhood of $2 million on lawyers through ICM to undermine the estate's ownership interest, which of course under the second order we're going to deal with, they were unsuccessful doing. If I may, if you don't have a question right now, I'd like to go through what the removal order found as a matter of fact, so that you can confirm, as I tried to do for you in the brief, that the record supports every one of these decisions. The first one,
and you've indicated earlier, Mr. Ryan, our analysis is basically the removal of a personal representative is reviewed by an abuse of discretion. That's what our standard is, correct?
Correct.
All right, sir.
And you know, I think it's really important on this last point I was making about the distributions. You know, Judge Creer found at hearing that the evidence established that ICM had a consistent historical practice during decedent's lifetime. So this happened while Hassan Keita was alive, of using bonuses to distribute the net profits. And the testimony from Mr. Riley was clear. Hassan, and these are Mr. Riley's words, would pay himself the profits because he was the 100% owner. There wasn't anybody out there to complain about it. And that's what he did. Now, the Judge Creer goes on to say everyone knew this practice existed and that bonuses could not be paid to Hassan Keita after his death. So Andrew should have confirmed in writing with the PR on where the net profits would go, because the net profits should go to the beneficiaries of the estate, of which Andrew Keita is one among many. But that's not what he did. He took 100% of the profits and dropped them into his personal account after it, and without permission of the court, without permission of the personal representative, without permission of the beneficiaries, and without a board of directors. It's preposterous for it to be argued that Andrew Keita and his sister Lori were the board of directors. That is just not the case. The only proper board of directors is the one that the personal representative convened using her power as the 100% shareholder in in mid-August of 2016. An act that brought proper corporate governance to this entity and would, if it had not been interfered with the ex parte order, led to a lot of this going away. Your Honor, may I ask how much time I got? Do I have like 2:20s for each one of these orders?
You have 4 minutes left in your argument. Is that what you're asking?
Well, it is, but I was thinking I've got 2 different orders I'm trying to protect.
Okay.
And do I get 40 minutes to protect the 2 of them?
No. I think we talked about it's 25 minutes total. And I hope that was your understanding.
Well, okay, you know,
I tell you what, Mr.
it wasn't my understanding going into this, but I get it now. So let me jump real quick to the the order that found the petition for directions to be time barred. The first clue that petition for directions is a nullity is its name. I'll use up most of the rest of my argument just describing what this petition claims it to be. It certainly isn't authorized under any rule. There's no rule of probate. There's no rule of civil procedure. There's nothing that suggests a petition. There's nothing that suggests that Andrew Keita had any standing to bring a petition to get directions for a declaration of ownership. Where does that come from? When you look at the relief that he's asking for, he's essentially asking for relief to have a court in New York try to figure out some undisclosed claim for ownership. That it does not assert anywhere in it a particular outcome or a particular ownership. It basically says we've got this, I think they call it in their brief, a convoluted materials, and then they want Judge Creer, the probate court, to give them directions of where they should go to whatever court of competent jurisdiction and determine ownership. Courts are not here to give legal opinions. They're not here to litigate non-existent rights. Any right Andrew may have had, and he never had one, but in 2018, when he filed his claim, he claimed he had an ownership. He voluntarily dismissed that claim at the beginning, or just a couple of days before an evidentiary hearing, where his mom's estate tried to claim that there were that she was an ascertainable creditor entitled to notice. Judge Creer ruled against her, had a big evidentiary hearing, learning about what was known and not known about ownership during that critical period. between August 1, 2016 and November 1, 2016, the so-called non-claim period. And there was nothing that suggests that anybody but Hassan Keita owned 100%. That order was appealed, by the way, to you, and Mom's estate lost. The sisters filed claims. They've abandoned their claims. They're all finally resolved. There are no pending claims below. There is only this petition for directions filed 3 years after the decedent's death by somebody who voluntarily dismissed their own untimely claim. And therefore, it doesn't present a justiciable controversy, and it is barred by the applicable statutes of limitation under the probate code. And with that, I think I rest.
Thank you, Mr. Friedkin. I'm going to trouble you to please mute your microphone, and then Mr. Burlington, you've got your 5 minutes, sir, for rebuttal.
Your Honor, there are a series of false statements here, and what is being done is procedurally, this personal representative is trying to assert 100% ownership of a corporation when she knew at the outset that those shares were not issued to Hassan when the corporation was created, and she and her counsel have admitted they have never seen a single share issued in Hassan's name, and beneficial ownership was not alleged in the inventory. It was 100% of the shares, and they misrepresent what occurred in front of Judge Schenko, and they misrepresent what the order said. What Andrew presented was what he believed at the time, and there were discrepancies and there were documents indicating, among other things, that Hassan had created a will and they couldn't find it. And he makes a big point, oh, but there's no will. See, he's lying. In fact, the PR's attorney testified under oath that he concluded that Hassan had destroyed his will. So that attempt to, you see, there's a whole series of attacking credibility that are simply unjustified. Now, we addressed this in the brief. There was no secret distribution of profits. And when he talks about Riley, who is the corporate accountant, saying that Hassan distributed the profits to himself because he was the sole owner, he said no such thing. His audited financial statements from 1999 on were unequivocal that the siblings owned the shares. The distribution in the form of bonuses was not dividends, as the trial court erroneously found, and Riley explained why that is harmful to the tax liability of a C corporation. And the bonuses were not paid solely to Hassan. Andrew and his sister Lori were paid approximately $1 million in bonuses the same years that Hassan took the bonuses, and they all recognized that he provided the primary strategic guidance, engineering guidance. He was involved as a consultant, and that's why he was paid. But they have never produced, and they argue that, our board of directors is wrong because the PR, who is 100% owner, did this. They have no evidence that Hassan was the 100% owner. Nothing. They have no shares. They have nothing except the IRS returns, which were not statements of Hassan. And they're trying to achieve procedurally an unfair result and foreclose any evidence on these issues. And when Andrew put the money that was, and it wasn't all the money, it wasn't all the profits. Riley testified at length of the consultations involved in what would be the bonuses and how they were to be distributed and why they had to go into an individual's account, and it saved the corporation $1.7 million in tax liability. That's in the record. Well, this discussion about, now the corporation's got all these problems, there's no evidence of that in the record, none at all. And he's just trying to portray Andrew as being, and Andrew did nothing to undermine the ownership claim of the estate. He gathered evidence, and Holland and Knight did 4 reports provided to everybody along the way, and if the PR hadn't held on to the 1984 stock book for a year and a half, knowing that that showed that Hassan did not have any shares at that time, they're the ones that interfered with the administration of the estate. Andrew spent the money of the corporation on this investigation. The order of Judge Schenkel was not limited to the specific documents attached to the petition. Andrew was given the power of a personal representative and directed to locate, among other things, corporate documents related to the ownership and or disposition of ICM Control Corporation. And that's what he did. The fact that the evidence, and it's overwhelming now, cuts against the estate's claim, Andrew didn't create that evidence. There's no suggestion his investigation wasn't thorough. There's no suggestion that he manufactured documents, no evidence that he destroyed documents. He did an investigation through Holland and Knight and presented it in these reports. The PR had them, and the minute the last report, which concluded that now there are really significant issues because the Articles of Incorporation of 1999 were discovered that authorized the issuance of the share to the children. That's when she decided, I have to remove Andrew. I have to, get this thing resolved procedurally. But to say that all along, the personal representative had these rights as sole owner of the corporation, when the evidence now and their attorney, Engel, the PR's attorney, admitted he's never seen a share in the name of Hassan. And beneficial ownership is not what they pled. And there's nobody saying that there's no evidence in this record of Hassan telling anybody, either Riley, the attorneys for ICM, the children, any documents after 1999 that he owned any interest. And there's evidence that he was 2 weeks before he died, he was preparing estate planning documents, and he told that attorney that he doesn't have any interest in ICM. Now, this is a convoluted situation, no question about it, but any of these decisions have to be driven by facts. And I might add, he made no argument to explain the cases and the distinction that we laid out very clearly in our briefs, that because Hassan never asserted it prior to death, it is not a creditor claim. And he made no attempt because he really can't rationalize those cases. We've laid it out. Many of them are from this court, and they make it clear. And what happened here, yes, it's a convoluted situation, not created by Andrew, not created by the siblings, but the facts should drive this because procedurally, Lori and Andrew were not barred because this issue arose after death. There was no liability on the part of the decedent created prior to his death regarding any ownership issue. And that's the law, and that's a question of law. And so we believe that the issue on the creditor, what they claim is a creditor claim, and we say is a dispute over ownership, is not the 3-month deadline. It doesn't fall within that line of cases, either under the statute or the interpretation, and that the removal, as we've explained, he did exactly what he was ordered to do. The fact that the facts turned against the estate, he didn't control that. He was doing the best he could with the information he had, and there's no question that the company was properly operated and increased in value, and it is unfair and in violation of the way the probate code is designed statutorily to prevent him, and there's no citation of authority that he cannot ask for a deck action in a probate action. We've cited cases on that in our brief. You don't have to have a specific rule of procedure when the facts develop like this long after the estate, and that delay is attributable to the PR for at least 18 months for the withholding of that information. So under this situation, the law and the equities favor. All we're asking for is an evidentiary hearing on the ownership issue. Andrew has never claimed he was 100% owner. He was doing it on behalf of his siblings in the corporation, and the manner in which this corporation was designed, albeit for a variety of reasons, and the way the documents, which nobody has challenged, demonstrate the ownership was spread out among the siblings. And under these circumstances, we should be entitled to an evidentiary hearing to have the truth come out and not just accept this presumption that because the PR asserts ownership in the inventory, no one can challenge it thereafter.
Very good, Mr. Burlington. Actually, you've now reached your rebuttal time. I just want to commend you both. You did a a fine job arguing a very complicated case. So I want to thank you all at this time. And I believe this was